Okay, we're here today with Professor Jennifer Koshan at the University of Calgary. Professor Jennifer Koshan is going to talk about the various things, rape shield, consent, and various aspects of the Justice Camp judicial complaint. Jennifer Koshan is, of course, very graciously taking time out of her busy day. Professor Jennifer Koshan, she is an expert, and she primarily lectures in constitutional and human rights law, and she is, in fact, working on a textbook specifically with that. However, another one of her passions and interests would be researching the area of violence against women, and to the point that, in fact, she's been very active with LEAF, the Women's Legal Education and Action Fund, more recently doing things like writing factums for them and advising them. But she was also a staff lawyer. Before that, she was a Crown prosecutor up in the Northwest Territories. Now, Professor Koshan, thank you. So, Professor Jennifer Koshan, if you could, thank you very much for taking time out of your day. What I was hoping was we could just cover a couple things, maybe for people that aren't as familiar with concepts like consent and rape shield and things like that. So maybe, because that'll be sort of maybe an educational component, and then we'll get to the complaint against Justice Camp. Very broadly, could you tell me what rape shield is? What is that? What kind of thing is that? Could you explain that to me, please?
Sure. So, first of all, I think it's important to note that our sexual assault provisions in the Canadian Criminal Code have really evolved quite a lot in the last 20 or 30 years. And I think in part that's in keeping with the efforts that activists across Canada have implemented in terms of making our sexual assault laws achieve a better balance between the rights of the accused person and the rights of women who come forward as complainants of sexual assault. Well, women and men who come forward as complainants of sexual assault. So the rape shield provisions have been around in one form or another since the 1980s, but currently what the rape shield provisions in the criminal code do is limit the extent to which evidence about the complainant's sexual reputation and sexual history can be introduced before the court. And so it's section 276.1 of the criminal code, which says, first of all, procedurally, if evidence about the complainant's sexual history is going to be introduced in court, the accused has to make an application to the court and explain what the relevance of that evidence will be before the judge can hear evidence of the complainant's sexual history. And that's whether we're talking about previous sexual activity with the accused or with some other person. So that's a really important procedural safeguard in the criminal code. But there's also a substantive component to the rape shield provisions, and that is to provide that a complainant's sexual history should never be seen as relevant to issues of consent or credibility. So regardless of whether the complainant has had a very active sexual past or not, we should not think about that as having any bearing on whether she consented to the sexual activity on the question that is the subject matter of the charge before the court. And same thing with respect to her credibility. Even if the complainant has had a very active previous sexual life, maybe a sex trade worker, or any other aspect of sexual history that may come into play, that should not adversely affect the complainant's credibility. So that's the substantive component of the rape shield laws.
Okay, all right. Well, I think I understand that. Now is there? I think another thing that would come up with this would be the law of consent. I believe that was a big part of this. Could you explain how that works? Is that a clear-cut thing, or how would that work?
Yes. So again, the law of consent has evolved quite a bit in Canada over the last several decades, and what the current consent provisions of the criminal code provide is that consent is the voluntary agreement of the complainant to engage in the sexual activity with the accused that is the subject matter of the charge before the court. So it's a subjective standard of consent. It has to do with what was in the complainant's mind rather than what was in the mind of the accused. And it's sometimes called the yes means yes law. So I think originally a lot of people advocated for a no means no law. They wanted men to take seriously women's exhortations that they did not want to engage in particular forms of sexual activity. But this law goes even further in saying that only when a woman actually affirmatively expresses consent to sexual activity can she be seen as consenting. So there's a connection there as well with the other issue that often comes up in sexual assault trials, which is mistaken belief in consent, which is more of a focus on the accused and what was in the accused's mind at the time of the incident. And the law of mistaken belief in consent now requires the accused to take reasonable steps to ascertain whether the complainant is consenting to the sexual activity in question. So there's both that sort of objective component when it comes to the accused's actions and the more subjective component that relates to the complainant.
Okay. Now, again, in my practice, this doesn't come up very much, so I'm very, very weak on the issue, so I appreciate you taking time to talk about it. Was that, now you say the law is that is, am I correct in thinking that's, you're basing that on recent case law, is that correct?
Well, on the criminal code itself.
Oh, okay. All right,
yeah, so on the actual...
Which sections are we talking about then? You may have said it already.
276.2, I think, or 272 and 273 perhaps, are the consent and mistaken belief in consent provisions.
Okay.
And then of course those have been subject to judicial interpretation. So the Ewanchuk case is one of the most famous cases interpreting the consent provision of the sexual code, and I think it really confirmed that what Parliament intended in the criminal code was an affirmative standard of consent.
Okay, excellent. Well, that makes sense to me. So let's and definitely not moving away from that, but maybe let's move a little bit to what has been in the news and why this has been in the news. And of course, we're talking mainly about it's Justice Robin Kemp, as he now currently is. First of all, there's been a complaint or a complaint made to the Judicial Council. Could we just start sort of with the basics then? What is the Judicial Council? What sort of thing is that? How does that work? What is it?
Yeah, so the Canadian Judicial Council is a body of judges that regulates the conduct of its peers. So it's similar to the Law Society of Alberta. You know, we have a peer review process for lawyers within the profession. Judges have something similar with the Canadian Judicial Council. Members of the public or members of the profession can make complaints to the Canadian Judicial Council about the conduct of judges, either sitting on the bench or I suppose in other aspects of their public life. And then it's up to the Canadian Judicial Council to assess those complaints. In appropriate cases, they will establish a public inquiry into the subject matter of the complaint. And then ultimately, if there is an inquiry, the Canadian Judicial Council can recommend the removal of a judge from his or her office. But it's only through an act of Parliament that a judge can actually be removed from the bench. To my knowledge, that's never actually happened. I think there have been a few cases in previous history where the CJC has recommended the removal of a judge, and then the judge has just resigned. And
not to put you on the spot, I thought was that what happened with, I believe it was Lori Douglas?
She ended up resigning.
She did.
Resigned.
Okay, fair enough.
The process never actually got to the stage of making a recommendation for whether she should stay or go. But there was a dispute about the photographs in that case and whether those should be released to the Canadian Judicial Council, and she resigned before it got to the point of them making a recommendation.
That's excellent. All I knew was that she wasn't on the bench. I hadn't looked into any detail, so I appreciate you clarifying that.
And maybe there's one other thing I'll add there.
Yeah.
Normally it is within the discretion of the Canadian Judicial Council whether to call an inquiry, and in fact the whole Lori Douglas case has added an extra step to the process. So it goes from the stage of a complaint to an investigation. The investigation can then lead to what's called a hearing council, and the hearing council then recommends whether or not there should be an inquiry. And all of that is discretionary at the discretion of the CJC. If, however, one of the justice ministers, either federal or provincial, asks for an inquiry into the conduct of a particular judge, then an inquiry will be mandated. And that's what's now happened in the Robin Kemp case. So the Attorney General of Alberta, Kathleen Ganley, after reading the transcripts in the case and I suppose reading the complaint itself, did ask the CJC to hold an inquiry into the Robin Kemp matter. And so those intermediate steps have now been superseded, and the matter will go to an inquiry.
Okay, so that's actually very interesting there, because I had actually assumed that, and again, I'm glad that you're clarifying that point. My assumption was that somehow the Judicial Council just decided to investigate it, but actually no. What you're saying is that it was Minister Ganley who in fact, for whatever reason, read yours, presumably read your other complaints and knew this was in the media, and then she made the recommendation, and that's what kicked the ball officially going. Is that correct?
Yeah, there was things happening simultaneously. So the CJC had undertaken an investigation as a result of our complaint.
Right.
It had called for this hearing counsel step to take place, but then in the meantime, Attorney General Ganley was also reviewing the materials, and she then recommended the inquiry, or called for the inquiry, and so now those intermediate steps have been superseded.
That's very interesting. I was completely unaware of that, so I'm glad you clarified that. Let's get a little bit more to the meat of it in this case. What error, what legal, there has to be a legal error in the for this to occur, and obviously your position will be that it's a pretty big one. But what was the legal error? What happened in the in this particular case in front of Justice Camp? What happened there?
Yeah, in fact, I would say it was more than a legal error, because in my mind, and I think in the minds of many people, it's up to appellate courts to correct legal errors, and that's exactly what happened in this case. Justice Camp's trial decision was appealed by the Crown, so he acquitted the accused in this case. The matter ends up before the Alberta Court of Appeal. The Alberta Court of Appeal issued a very, very short judgment that didn't refer very much at all to the trial decision, except to say that the trial judge had made serious errors with respect to his application of the law of consent and with respect to his application of the rape shield provisions, and also that comments he had made throughout the trial and in his decision were reflective of myths and stereotypes about complainants in sexual assault matters. So I read the Court of Appeal decision. I was immediately intrigued, wondering what these myths and stereotypes were, and in what ways Judge Camp, or Justice Camp as he now is, had misapplied the law in this area. So I tried to get a hold of the trial decision and found that it was unreported. I was able to get a copy of the transcript and the Crown factum, which are public documents, but still hard to get a hold of sometimes. Sure. Yeah. And after reading through the trial decision, it became clear to me just how serious the errors of law were that had been made. And I think really at that point, in discussion with my colleague Alice Woolley and our colleagues Jocelyn Downey and Elaine Craig at Dalhousie University, we all agreed that his conduct went beyond simply making errors